But at the same time, if you publish less than what you're legally entitled to, you have to keep in mind that the defendant will have a right to buy the property back without competitive bidding at what that published upset is.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today, we're going to walk through New Jersey sales. Now, viewers of our show are aware that there's been a lot of changes to the Community Wealth Preservation Program. And today, we're going to step back a little bit, both cover how New Jersey sales operate in general, and then how the CWPP is impacting New Jersey sales. I'm joined today by Friedman Vartolo associate, Perry Russell. Perry, how's it going?
Doing great.
Thanks for coming back and joining me here today. Let's jump in. So we know the Community Wealth Preservation Program has made a lot of changes to how the sale process works. Before we get into that, let's talk really high level about how New Jersey sales operate.
Sure.
Right? So when we're post-judgment and we want to schedule a sale, what do?
So we need to prepare what's known as a concise description. It's basically identifies the property, the dimensions, as well as identifies any liens that are on title that would survive the foreclosure. We provide that with the writ of execution of the sheriff's office, and they use the information we provide them with to prepare sale publications that will run for 4 weeks before the sale.
Okay, and then we're reviewing, the attorney for a plaintiff is reviewing the sales publication.
That's correct, yeah.
All right, and then how long roughly from that package being received by a sheriff is a sale scheduled?
It could depend on the county, but the average is somewhere around 20 to 30-ish days.
Okay, and then when will the sale actually occur?
The sale, since the publications need to run for 4 weeks, it's usually about 4 or 5 weeks from the time the sheriff actually puts us on the date. There's usually a week of preparing the publication and drafts, getting them approved, and then the 4 weeks of them actually published.
Okay, so assuming no adjournments, we're looking at somewhere around 2.5 to 3 months, kind of in best case scenario.
That's a safe bet.
Okay, and then we, or us or plaintiff's counsel, has somebody appear at the sale, right, once the sale actually occurs.
Yes.
Walk us through generally, like what happens?
So generally at the sales is there will be a vendor. Many plaintiffs' attorneys use the same vendor. So it will be a service that does this for a lot of the firms in the state. They'll show up, they'll appear at the sale, and they'll get up and basically start the bidding at the opening price of $100 or $1,000. It depends on the county. And from there, interested parties will bid usually in increments of 1,000. Again, that depends on the county, though. And it will go all the way up until we hit what's basically known as the upset price, which is the minimum amount the plaintiff will take to satisfy their judgment. Once we hit that amount, the vendor on behalf of the plaintiff will stop bidding. And if there are still interested third parties at that point, they'll continue to bid up in the same $1,000 increments until the sale's struck off, and the sheriff is going to get a cut of commission out of it, and the deed will be prepared.
So prior to the CWPP, there was no right of refusal, at least not that I'm aware of.
No, all the foreclosure sales were competitive bidding.
Initially, it creates two rights of refusal, which in essence function as almost like a buy now price that a party can invoke prior to the sale commencing.
Correct.
Right? To recap for us, of those two rights, what was changed?
Pretty recently, the right of second refusal, which applies to nonprofit corporations, was struck down as unconstitutional. So now the right of first refusal is the only one remaining, which applies to next of kin, tenants, and people like that.
So what we're saying here is the next of kin, tenants, everybody else who has a right in the first refusal can, in essence, buy the property for a price.
Correct,
right?
Yeah.
Which is set by plaintiff.
Yes.
Prior to the foreclosure sale, which then really changes that answer you gave me in terms of what happens at sale, because there's no sale.
100%.
And then previously, prior to this, the ruling striking down the second right of refusal, this right also existed with nonprofits.
Yes.
From your perspective, is there anything else that's changed lately? Like, is this where we are right now?
This is where we are right now. The right of first refusal is still in place, though I don't anticipate that staying indefinitely for the same reasons that the right of second refusal was struck down. There's certain concerns, certain takings concerns for junior lien holders who don't have a chance to preserve their liens if the right of first refusal is exercised.
Let me just jump back into one question that we've probably covered a million times together on this show, but I think it just is important to bring up again in an episode like this. So when the first right of refusal was created through the CWPP, the plaintiff now has to give its upset figure earlier. So can you just walk us through, like, what that meant practically for servicers, just in case you have a servicer who maybe hasn't had a loan in New Jersey for a while. I want them to be aware of what the change is and what they have to expect.
Sure. So prior to the CWPP, there was really no information that the plaintiff provided to the sheriff for the sale publications regarding their upset price or judgment amount. And many of the sheriffs would just take the face judgment amount from the docket and put that in the sale publication as approximately this much is owed. Once the CWPP was enacted, they started asking for what they referred to as a good faith estimated upset price, which needs to be included in the sale publications. Now, there's a good bit of confusion and I think lack of consistency across the counties on how this is handled, because there is a distinction between what a final bid at sale is and what an upset price is. And so we've seen some issues where if, let's say, a plaintiff decides they want to bid less than what they're legally entitled to collect, the good faith estimated upset price, we've seen some counties raise concerns about the bid being below what was published as a good faith estimated upset price, while the upset price itself is the total amount that plaintiff is entitled to, which what's published. The bid on the day of sale might not necessarily match. And while it's my belief those two things are two distinct numbers, many of the sheriffs are kind of conflating them and treating them as the same thing.
What's the difference between an upset price and the total amount owed to plaintiff?
The upset price is what plaintiff is willing to accept.
Okay, so the upset price is really tied to plaintiff's belief as to property value, you would think.
Usually, yeah.
Okay. And so when plaintiff is giving our office or other firms that handle this type of work in New Jersey, when they're giving us the upset price, how soon prior to the sale do they have to give that to us now?
We would strongly recommend providing it before any sale publications are prepared or run. So we'd say before we even have a sale date, once judgment's entered, we want to start thinking about what your upset price would be, because we want the sale publication to reflect that.
And it's important to highlight that because I think in most states, at least the other states that we handle, we're dealing or we're receiving or requiring to receive the upset price as early as an hour before sale. We just have to know what to bid, right? New Jersey with the CWPP created this additional requirement where that figure is required an extensive period of time prior to the sale, and you're kind of stuck with it.
Yes.
Correct me if I'm wrong here, but while that recent decision removed the second right of refusal, it did not change the requirement that this upset price has to be provided so far in advance.
That's correct. I also think it's important to note that if you want the upset price to be as accurate as possible, as early as possible, if you're willing to take less than what you're legally entitled to, that needs to apply consistently, because if you're going to bid less, the upset price is going to limit your ability to do that. But at the same time, if you publish less than what you're legally entitled to, you have to keep in mind that the defendant will have a right to buy the property back without competitive bidding at what that published upset is, right, even if it's not the full amount owed.
Yeah, I mean, we have some clarity. I think the mortgage holders had a bit of a win, but there's still some complications here.
Absolutely.
All right, but this is good. Something tells me this is not our last show on the CWPP, but until next time. Thanks for joining Perry Russell and I in the Weekly Friedman, your source of the most essential information in the default industry. Thanks for tuning in. I'm looking forward to seeing you next time. This is not the first video we've done in the CWPP. If you're interested in seeing some prior videos on this topic, you'll see some links on the screen.